Well, good evening, everyone, and thanks so much for joining us tonight for the next session of the Citizens Law School, presented by the State Bar of Montana Law-Related Education Committee. My name is Michelle Lyde, and I'm so glad you've taken time out of your day to be here. Our hope is that you walk away from tonight with some practical information that helps you better understand our Montana legal system. Probably help if I could talk too. On that note, we're so lucky to have with us tonight Hertha Lund. Hertha is going to speak to us about water, property, and federal land law. We all have our path to law, and Hertha is no different. In 1982, Hertha was working as a journalist covering Congress and the Supreme Court, and she was assigned to report on one of the most important cases regarding the Fifth Amendment, Lucas versus South Carolina Coastal Commission. Her experience that day, along with her life growing up on large cattle ranches, catapulted her into a career fighting for private property rights. And that fight has continued. She's been fighting for landowner rights for more than 30 years. As the founder and owner of Lund Law based in Bozeman, her practice includes the areas of property rights, litigation, eminent domain, and water rights. She has trial experience and has prevailed in high value cases involving property rights. Hertha has appeared before the Montana Supreme Court, the Federal District Court of Montana, the Ninth Circuit Court of Appeals, and the United States Court of Federal Claims, along with the United States Supreme Court. When she takes a minute away from work, you can find her riding her horses, helping out with the ranch work on the ranch where she lives with her husband, and working on her memoir. Hertha has also started coaching clients through her newest endeavor, Four Horses for Wholeness, partnering with horses to serve people through the equine gestalt coaching method. And it's as if that isn't enough. She's recently taken up photography and is busy snapping photos around the ranch. Please join me in welcoming Hertha Lund.
Well, good evening, everyone, and I'm so glad you're here. I do have a PowerPoint to kind of help us follow along, so I'll get that dialed up for you. And so let me know, Michelle, if you can't see the PowerPoint.
Hertha, we can definitely see it, but it isn't in PowerPoint mode, right?
There we go. Okay. All right, there we go. So this is my law firm. I've had my own law firm for I think about the last 14 years. And so first of all, I want to kind of tell you about, we don't think a lot about our founding fathers that much anymore. And the founding fathers of America understood clearly that private property is the foundation, not only of prosperity, but freedom. Many constitutional lawyers and thinkers, will say that property is kind of the foundation of all of our rights. The Fifth Amendment to the United States Constitution says that nor shall private property be taken for public use without just compensation. Also, the 14th Amendment has due process protection, which states that you can't take property without due process. And so what does the word takings mean? Takings means when the federal government or the state government or a local government or any other entity, sometimes a private entity can also take property, but those are very limited because it has to be for a public use. So if it's a public use and it's necessary, they have to prove a lot of things, then they can take property through the process of eminent domain. However, if the government takes property under eminent domain, or in those circumstances, a private entity has the power to make it into a public use. And that's kind of like the power lines. Some of those are not totally public entities. And so it can be kind of a quasi private entity that can use the process of eminent domain to take property. But when they take it, they have to pay just compensation. Just compensation is the price that property would be paid for. It would be paid for the property if it was a willing buyer or willing seller. And then there's what's called a regulatory taking. When I covered the case of Lucas versus South Carolina, that was a case in the 1990s. And what it was is the state of South Carolina didn't want David Lucas to build a house on his property on the coast. They said that it probably wasn't a good place to build a house. So state court said that was fine, went up to the Supreme Court, and the Supreme Court said, no, that looks like it could be a regulatory taking. And they sent it back down to the state to do some more findings. And the state decided that they would take it. And so they took it, they paid David Lucas, and then they sold it for development. Kind of ironic. Another type of taking is a physical taking. And it's like, well, how would that come about? That would come about, like, if you look at some of the big dams that the federal government put in, in the early 1900s or something, they sometimes flooded the land. And that would absolutely be a physical taking. There's another case up in front of the United States Court of Federal Claims. That's where all takings cases that are larger amount of money are heard against the federal government. And there's currently a taking case against the Forest Service for starting a fire and letting it get out of hand and burned onto private ground. So those are all types of physical taking. So the Montana Constitution also has a clause that has to do with protecting private property, and it's Part 2, Declaration of Rights, Section 29. Private property shall not be taken or damaged for public use without just compensation till the full extent of the loss having first been made to or paid into the court for the owner. In the event of litigation, just compensation shall include necessary expenses of litigation to be awarded by the court when the private property owner prevails. So basically, this is very similar to the United States Constitution. However, in Montana, when they did the 1972 Constitution, they wanted to make sure that if the government was taking a private property, that the private property owner would be made whole, which includes being paid his expenses of litigation, because he wouldn't have had to spend that if the government didn't come to take his property and make him an offer, or sometimes they try to take it and they're outside the boundaries of their power. So if the private property owner prevails, the government has to pay. So this also includes when the Montana Department of Transportation takes property for roads and stuff. So more about property rights. What are property rights? We oftentimes think about the sticks and the bundle of sticks when we think about property rights, and it's the if you own your house, you have the right to exclude others from your house. You have the right to occupancy. If you own barren land, yes.
Hertha, can I interrupt really quick?
Sure.
It doesn't look like your PowerPoint is cycling through, so you don't have it in presentation mode. Is there? And so I think we're just still stuck on the first one. I thought it might just be me, but we're getting a couple comments that stayed as much.
Wow. Okay.
Apologize that I didn't catch that earlier. I just thought I was on yours.
That's good. I haven't said much else that wasn't on there, so I don't. Okay, I'll stop share. Go back.
And then everyone, thank you so much for calling that to our attention. Also, if you have some questions for Hertha as she's going through things, please put those in the Q&A. And after each portion, she will address those questions that you may have.
How about now? Can you see more about property rights?
Yes. Okay, that sounds perfect. Thank you.
All right. So the property rights, it's the right to use the property, the right to exclude others, the right to lease property, the right to build a house, all of those types of things, wind leases, solar leases. And so did it switch now? Did the slides?
I apologize. It did.
Okay. All right. So the other ways you might use your property is for agriculture. You might want to just, have a garden. Some people want to mine, but if you want to mine, that brings in another property right, because mining is not only a right to the surface of the property, it's a right to what's underneath it, and it's a separate right. So mineral rights and oil drilling rights are different than the surface rights. And then I'll talk a little bit later about road easements. So those are all different types of property rights. And all of those are compensable if the government takes them without compensation. So whenever I get to a slide with a horse on it, this is the time where if you have questions, I'm going to switch now and talk about water rights. And then we'll go back into easements. So any questions, Michelle?
No, it doesn't look like we have any questions. Thank you.
All right. And this is my lovely Gypsy Shire Mare Mystic. So It's very interesting how we got our prior appropriation doctrine in Montana. Across the West, the scarcity led to the development of the prior appropriation doctrine. That's what we follow in Montana. And so if you, in the East Coast, they have a riparian doctrine, which basically means if a stream runs through your property, you can use the water. That wouldn't work in Montana, because think about how far we have to move water to where it's beneficially used. And since a lot of Montana's history was, Montana was settled and developed at first a lot with mining, how we developed our property interests and water rights followed very closely to mining. So the first person to divert water and put it to beneficial use acquired a property right to the amount of water diverted. And the appropriation, the first principle for the prior appropriation doctrine is first in time, first in use. So what it means is let's say, for our ranch, my husband's family came over from Norway in the 1800s before Montana was a state. And so when they put water to use, that's a really old water right. And let's say somebody came over, developed their property for ranching in 1925. The first in time, the oldest right, if there's not enough water for irrigation or for other uses, the first in time gets to use it first. And the people who are lower or higher in priority date, later in priority date, they may not get to use their water. And there's a lot of streams in Montana that at times of the year, they do start measuring and putting out lists of who can use water, and the later people with later prior appropriations don't get to use their water. The second principle about water rights is that the water must be put to a beneficial use. And the reason that's important, because if you don't put the water right to beneficial use, you lose it, and that prevents waste and speculation. So your water is a scarcity, and the prior appropriation doctrine is a way to allocate that so that it is put to beneficial use or it's left in the stream. So a little bit more about water rights. The other states that have the prior appropriation doctrine are Arizona, California, Colorado, Idaho, Kansas, Nebraska, Nevada, New Mexico, North Dakota, Oklahoma, Oregon, South Dakota, Texas, Utah, Washington, and Wyoming all have a legal system based on the prior appropriation doctrine. It's either a complete replacement for or in addition to the traditional common law riparian system. So some of those states have a dual system. That would be really hard. And when we think about a water right, we can go back to what we learned about land or real property, and water right is also a real property interest protected by the takings clause. But we talked about this, this bundle of sticks of a property interest. And so if you think back to land, an individual may own a right to use and occupy a parcel's surface, while another individual has a right to develop its underlying mineral, and a third person might have a right to travel across the surface pursuant to an easement. And a fourth person might have a right to utilize the airspace above the surface. And that would mean that all of those people own a stick in the bundle of sticks. Sometimes a landowner possesses the property in fee simple, meaning that the landowner controls the parcel in all respects. More often, though, multiple individuals control one or more sticks in the single, instead of having all the sticks in the bundle of sticks for property interests. So in water, it's different. Property interests and water rights also resemble a bundle of sticks in that one person might own a right to divert water for irrigation, while another person has a right to float on the surface, and a third might have the right to fish in the water, or there might be in-stream flow rights for fish. And a fourth has a right to use the flow of the stream to power a mill. And the fifth may have a right to dispose of waste in the water. Some of these uses are simultaneously compatible. However, so for example, the mill can be powered by water, and somebody else may be able to use the water for livestock. But for the most part, unlike land, water uses are not simultaneously compatible because it's a consumptive use. And that means that the water is diverted out of the stream and then consumed for irrigation, or it's consumed by a town, or it's consumed by a house, for use. So that's, very similar but different. And so the water right is a right to use a certain amount of water that's diverted from a certain place on a certain piece of property for a certain beneficial use. And it is a usufructuary right. That's still a real property interest, as I said earlier. And as anybody knows, in Montana right now, having a valid water right has a huge impact on the value of the real estate. I don't know if you've paid any attention to the legislature and stuff, but and maybe if you own land, that we're going through an adjudication. We started the water rights adjudication in 1983. And what is the water rights adjudication? We have all these people who filed claims of water back to the the late 1800s, when they put water to a beneficial use. And so maybe, let's say, and my neighborhood, some of those early Norwegian settlers, you put water to beneficial use, and they said, I'm using it over here on this parcel, and it's 160 acres that I'm irrigating, and this is when I use it. But a lot of those claims may not have been 100% accurate as to how much they used, where they used it, type of use. Sometimes there's typographical errors. So adjudication is the truing up process in which individuals get to, they can object to their neighbor's water rights and say, that's not quite right. They can object to their own water rights if there's a mistake, and the Montana Department of Natural Resources also reviews them. So they're trying to clean up all the mistakes in those filings that occurred back as early as the late 1800s and early 1900s. And they thought when they first started it might take a couple decades, but started in 1980s and it's 1923, and I think we probably have another, 5 to 10 years still. So, but when it's done, it will have all of these attributes of a property interest and a water right will be all trued up. So you'll have the right priority date, the right point of diversion, the right place of use, the right type of use, the right period of use, the right period of diversion, the right type of diversion, and the flow rate or volume. And this all gets put in a decree, and the decree becomes kind of like what a deed is to a land right. So that's my horse Monk. And so this is a time if somebody had questions. I'll also take questions at the end if you want to wait till then, but I'll check in now.
Hertha, I'm just giving everyone a moment if they want to type one in, but none so far. I don't see any if you want to continue. We'll just check back at the end.
All right.
Oh, so hang on just a second.
Okay, well, that's my Monk. I'll answer that question. He is a gypsy vanner. So
we do have one question. Is there a list of adjudicated water rights that's available?
Wow, there are lists of the water rights, but there's a whole system that the Montana Department of Natural Resources keeps. And then there's also records at the water court of what those are. I mean, I don't know how many thousands there are. I mean, you think about all the streams in Montana, all of them have water rights. So Montana, probably the best place to go if you wanted to be able, and there's an electronic system where you can search. And that would be the Montana Department of Natural Resources. They're actually just now releasing a brand new system of being able to look up water rights.
Great. And I think the next question we have, and it's something I was actually wondering about, is how will climate change impact water rights in your opinion? And are you seeing more litigation based on those concerns?
I haven't seen it yet. And, so that's a good question. I went to a seminar last year, talked at a national panel, and there was an attorney from California there, and they have a mixed system, and their system isn't quite as true to the prior appropriation doctrine. And they're starting to see some push and pull to try to allocate interest in water based on problems with when they had so much drought. And so but they haven't, they're kind of limited in what they can do because California also recognizes that water rights are property rights. So if the government comes in and says, well, we're going to reallocate resources because they're limited, there's a strong chance they will have to pay whoever owns that water right for the just compensation. And in scarcity, it does work. The property rights are allocated. It's just that some people may want them to be allocated differently. We also have the possibility in Montana to change water rights with the market. So this happened a lot in Colorado. A lot of the agriculture water rights around Denver are no longer used for agriculture. They were bought up by the cities and, for use for developing more property and for keeping places green. So the market can work. So it'll be very interesting to see what happens, as the climate changes. So.
Thank you. We have another question, but I think it's going to be part of your next presentation. So I'll hang on to that until you're done with the next part.
All right. So the next part is about easements. And this goes back to the property interest, one of the sticks in the bundle of sticks. Right now, we work on property rights all across the state, and I'm kind of a boutique law firm. And I would bet almost a third of my caseload, if at least a third, has to do with easements. With all the development that we have and urban kind of running into rural, all this place where that line keeps on moving. A lot of people buy land and then they find out that they don't have the road that they want, or somebody has a road and our people start using it. And so an easement is an interest of land owned by another person, and they can use that or control that land. So let's say I have a 30-acre parcel and there's a road that goes through it, and the person next to me to the east has a access easement, a road easement. So that means that they can use that road to get to their place. Now, if that access easement is limited to historic use, and that the next door neighbor has always been a ranch, they would not be able to develop that place and use it for a subdivision. So easements are very tricky. They're very specific. And there's a lot of conflict going on over easements. So it's similar to a lease, but it carries more weight. And so a lease is a use of a property. So I could lease my property to you. I could lease my condo to you for a week or a year or several months. I could lease some agricultural property to you to hay. There's all types of different leases. But an easement is actually a property interest that you own. So it's not limited by time and use as much as a lease. Easements are also defined by statute in Montana law. So it's a written easement. It's by, like for a road that could be by prescription. By prescription, it means, well, you can also move your lot lines by prescription. It means that somebody's used it in opposition to the owner for a certain amount of time. And so if somebody uses a road, and I think it's 5 years, but I never try to remember these numbers. I always go and look them up. Then you can establish an easement by prescription, but you have to use it you can't use it with permission. You have to be using it without permission. So the law thinks that if you don't, if somebody lets you use it that long and you're not supposed to be using it, that you've gained a right. But if you've been given permission, you can't get it by prescription. There's also questions about where county roads are. And so those are all types of road easements that we can argue about in court. And sometimes you can get it by hook or crook. You would not believe some of the issues I've seen happen with road easement cases. Besides road easements, we also have wind and solar easements. I do a lot of work for landowners on wind easements, and there's some recent interest in solar easements. And then I had ditch easements. In Montana, we have a common law that if you have an irrigation right and it's carried in a ditch, you automatically have a ditch easement. And sometimes you had conflicts between new owners and the old owners about where the ditch goes. So it must be I guess there's not a horse here, but this is also a place for a question.
Bertha, I think that you answered this, but just to reiterate, if you wouldn't mind, we have a question. How does a private road easement work regarding neighbors' right to cross? Do the users need to have an agreement?
If you have an easement, you do not have to have an agreement. However, you have to, the easement will be very specific about what it's for, you know, and if it's broad and it runs with the property, then it might be broad enough to, you know, to do whatever you want with it, but it's all very specific with the language. But you do, if the road goes through you and to their place, you may have to have a road maintenance agreement. Maintenance of the road is different than the right to access. And so those oftentimes people, you know, want to figure out how they're going to take care of the road, because many of these roads, you know, even around Bozeman, you have to maintain them yourself. The county doesn't maintain them. So that would take an agreement, and that's what I would recommend, trying to figure that out. So.
Thank you. And the next question we have is, do prescripted easements have to follow historical use? For example, a road was historically only used in summer. Can the second owner now use it year round?
No, if you could only get prescriptive use for how, well, it depends on how you use it. Whoever got it by a prescriptive use could get the prescriptive use that they got, you know, over time, over the 5 years or whatever. It's kind of like a way that the law allows you to establish a property interest in somebody else's land. Now, note, it's not very well liked. Right?
Thank you.
Yeah.
Yeah, definitely. Those are the 2 questions that we have. Thank you.
All right. So mineral rights, just one slide on this, because we talked on it brief about it earlier, but this is a severable interest. So, and I don't know how many of you remember the dinosaur case. That was about eastern Montana defining these big dinosaurs, and there was a big argument that went up and down through the courts and up and down the Supreme Court. And the argument was it a mineral right? Was, you know, dinosaur bones, was it minerals or was it like a gravel interest? Because one goes with the surface and one goes with the underlying mineral rights. And I can't remember for sure. I think they decided that the dinosaur went with the surface, but I'm not 100% sure. But the reason it matters is because the mineral rights are what's underneath the land is a severable interest. So that means we have a split interest. We have a split of estate in Montana and in many of the Western states. And so if somebody has mining or oil and gas rights, it's separate from what's on top, and the mineral right trumps. So if you get into a conflict, the mineral right wins. So that's also a little disconcerting if you own the surface. So, well, you guys might have to have some questions, or I do have a little bit more material on the history, but so.
Bertha, I can kick in and let you know that dinosaurs are not minerals and they belong to the surface estate. Sweet. I just Googled that.
Thank you. I got it right. Phew. It's always scary on these when you, yeah, and this is why after practicing law all these years, I still go look things up instead of try to remember them. So how many, you guys realize that Montana is 30% owned by the federal government? And you might think, well, how would that happen? Well, if you go back to, if you look back at how Montana was homesteaded, you know, the homesteaders came and, you know, nobody could really make it on, you know, the acres that they got in a homestead, but they tried. And a lot of those homesteads were put together and built into ranches. But the government, federal government, not all the land was homestead developed, and some was put aside. So we know we got the Yellowstone Park, we got the Glacier Park, you know, then we have the Indian reservation. So that was land that was set aside for the tribes. And then we got the Forest Service and the BLM, and that's also land that wasn't homesteaded. So the reservations and the parks, those were kind of choice pieces of land, or at least land that they had an intention of putting aside for a purpose. A lot of the Forest Service and BLM land was land that wasn't homesteaded. And so, those are mainly the ways that we have federal land. And I went with federal land instead of public because the federal government owns all that, but it's not necessarily that the public can use all of it. And the public is limited in how it could use it. So I kind of tried to name it with something that seemed better. And the state government also owns land, and that's totally different managed. The state has a duty to manage its land for the best, the best interest for the funds for Montana. So it's a different type, but they also lease some land for agriculture. And it depends on the type of land, what the public can do on the land. And this will probably be where it gets really interesting. Oh, no, that's the next slide. So federal land is mostly managed. I'm not now talking about the parks or the reservations. And of course, the reservations arguably are not federal land anymore. They belong to the tribes, but the federal government has a trustee duty to the tribes. And so the land has been totally separated over the last 2 or 3, 4 decades from the federal government, but they still have a trust duty. And so the federal land is mostly managed for multiple use. And now when we're talking about multiple use, we're not talking about the parks, the national parks. Those are managed for parks. But the other ones, the Forest Service and the BLM, we also have federal land that's the monuments. And those are not also, they do have some multiple use, but they have a different type of management goals on them. But they manage them for wildlife. And I didn't put these in any order because I realized that there are there's a coalition for each one of these, and none of them want to be at the bottom of the top of the list. So I just wrote them down as I remembered them. It's not any order. Recreation, grazing, timber, mining. And there is quite a bit of litigation still about multiple use on the federal lands. And that goes to the issues of, I'll come back to bison, but if you have federal lands, they have to follow the National Environmental Policy Act, Protection Policy, I think. And so if you're going to do anything different, like if you're going to change a grazing permit, or if you want to do any timber harvest, you have to do an analysis, an environmental impact statement to see how it impacts everything. And so there's a lot of issues about that. Of course, you have to be aware of the Endangered Species Act. And hunting is a big issue on the federal land, the Forest Service and the BLM. And there's a lot of discussion about corner crossing. Montana is a state where corner crossing is not automatically a legal right. I think it's still a gray area, but I wouldn't, if you start jumping corners when you're out hunting in Montana, you may end up in court. And so the problem with some hunting areas to get on Forest Service is access. And they have a hard time getting there because sometimes federal land is surrounded by private land. And so that's a big issue for federal lands, is the ongoing access. And the federal government and the state government has been trying to solve problems to get access to state land and the federal land. Now, this is an issue that I know a lot about that most people probably don't know a lot about. It's bison. And we have all of bison in Yellowstone Park. My husband and I went there last year, and it was amazing. We saw so many buffalo, and it's amazing how they can live there, throughout the year, and to see them, and people come from all over the world to see them. But the bison numbers have grown and grown and grown. And so Yellowstone Park, the bison come some into Montana down to, I think, about Yankee Jim Canyon. So that's on private ground. And I actually helped litigate some cases for a while, and some of the people who lived there were worried about the bison. And there was a guy who worked for the I think it was the park, and he said, well, we're going to put up these things for the kids to sit in when they're waiting for the bus, because if the bison are around, you really don't want your kid out there standing waiting for the bus. And I said, well, tell me more about that. And he said, we're going to get these Powder River panels. They were going to put the kids in these panels, Powder River panels, to protect them from the bison. So I kind of jokingly said, you're going to corral the children. And they've worked it out. But, you know, bison hanging out in your yard can be a problem because, as we know, they some of the tourists aren't so smart. So that's an ongoing issue for some people who live outside of Yellowstone Park and the bison that go. And then there's people who want the bison to run free. And then they say, well, why isn't the bison like an elk? Well, elk have caused less problems with interactions with people. And so, you know, a lot of people on the private ground and the ranchers don't really want the bison. So it is an area that, you know, keep on working at it at the state level and the federal level. And then it's a little bit different, but the American Prairie Reserve over by Malta has bought up lots of ranches, and they're running some cows, but they're also running bison. And they want to run it on the BLM. And there's a lawsuit going on right now, and I am a part of it. So I'm just going to give you an overview. I'm not arguing my case here. The American Prairie Reserve, I think, has argued that the bison are just like livestock, and they should be able to run on the Bureau of Land Management. The Bureau of Land Management has rules and laws that they're supposed to govern that has for livestock grazing. But the ranchers will argue that the bison aren't livestock, and so they don't belong on the BLM ground. And that if they want to put new wildlife on there, they have to go through a different process. And that's also includes some of the national monument area over on the Missouri River breaks. So those are the types of issues. And I think that these types of issues are probably, I mean, I've been covering Congress. I did that as a journalist in the early 1990s. And I worked on the Clean Water Act, the Endangered Species Act, and these types of issues that impact ranchers, and that, you know, the ranchers and the environmentalists don't agree. So I've been doing this for 30 years, and the issues don't really change a lot, it seems like, which is, you know, interesting. And I've done it also on the state area. So that gives us about 10 more minutes for questions, or I can go back and pick up some of the information about the property rights and the founding fathers that I forgot to give.
Hertha, we do have one question, and I actually have one.
Okay.
Are there any parcels of land today whose property rights are not disjointed, like you described, and thus available for purchase in fee simple?
That is a good question. A lot of land in Montana, the federal government also kept some of the rights. They kept some of the gravel rights. So those, and you have to look how it was homesteaded. So there's some areas in Montana that the federal government kept some of the rights. So those are severed. I know that in my area where we live, almost all the mineral rights have been severed from the the surface rights. So that is a really good question. I'm sure there's some places, I mean, any places that are smaller parcels, you know, even if there were severed mineral rights, you wouldn't be mining for, you know, digging for minerals in Bozeman. So, but no, it actually is a big problem. If somebody wanted to make a ton of money, they would get good at looking up mineral rights to be able to try to figure out who owns them all. I mean, it would take so much work to go to all the courthouses and try to figure out who owns them. Like in my husband's family, so you think back that he's the fourth generation. So for the last 4 generations, the mineral rights haven't followed the estate, and they've been given to different people as the land gets passed on, you know, by will, and, you know, to different members of the family. So some, you know, there may be 30 people that own mineral rights on some parcels.
Fascinating how in-depth it can be and how much history there is involved. Just the follow-up question I had was on corner crossings, and based on the ruling out of Elk Mountain Ranch, do you see anything changing on the horizon for corner crossings?
they run a legislation each year at the legislature. So that'll be an ongoing issue, I think. I would say, you know, the hunters, there are lots of landowners still in Montana that allow hunting, and it's not fee hunting. And I know from, you know, living out in the country and knowing the people who do that, that there wouldn't be as much problem with access issues if more of the hunters were. We have really good hunters, but every once in a while you get someone who isn't conscientious or careful. Think about it. If you have somebody running across your front yard, you may only own a lot in town, but still, if somebody walks across you, you want them to be, you don't want them to scare you, and you don't want them to be rude. So my belief is, and maybe this is Pollyanna, that the issues between hunters and landowners would be solved with just good manners, good communication. And I think that then would extend to corner crossing. I mean, there's just a lot of places that, you know, don't want people running all over them. The other problem we have, though, is that a lot of Montana has been bought up by out-of-staters. And a lot of times people come here because they're trying to get away from having to deal with people. And so a lot of those places that get bought up by people from out of state who want to kind of have their own reserve, they're not very comfortable. They're not very open in letting people come on. So there's just a lot of different issues that are focused on land in Montana. And of course, Yellowstone didn't help.
Yeah, I imagine you're seeing some of that.
Yeah.
You don't have any other questions right now in the queue? We have about, looks like a total of 15 minutes, but if you have like 5 more minutes that you wanted to talk about the founding fathers and information, I think we could all do a little bit of education. Never hurts any of us.
All right, so if you think back to the time of the founding, it's no accident that our nation, which was conceived in liberty, that it's dedicated to property rights. You know, because property rights are the foundation of every right we have, including to be free. If you think about all the other rights that we have, you know, in the Constitution, you know, like even rights to our religious freedom, freedom of speech. If you didn't have the right to your property, if government or the tyranny of the majority could take your property, that would mean that your right to be different, to have, you know, a different religion or all the other rights that are protected, you know, that you wouldn't be able to be as safe and having to be indifferent if you couldn't own your own house and be safe in that house. John Locke, who was a philosophical father of the American Revolution, and he was the inspiration for Thomas Jefferson when he drafted the Declaration of Independence, he stated the issue this way: lives, liberties, and estates, which I call by the general name property. And James Madison, the principal author of the Constitution, echoed those thoughts when he wrote, "As a man is said to have a right in his property, he may equally be said to have a property in his rights." And that's one reason why I was so interested in protecting private property rights, because I just believe that it was so much the foundation of each one of us being free, and all of our other inalienable rights that are guaranteed to us by the Constitution. And I can tell you by experience that doing eminent domain cases, it is very hard. I mean, working against the government, and you know, I've usually prevailed and been able to get my clients. Usually the state, you could say it's good because they're protecting our money, but they don't usually offer fair market value until an attorney gets involved. And oftentimes I have to work, you know, through litigation to make sure that my clients are adequately compensated. And it's a little bit of a David and Goliath story, but I do, you know, it is kind of why I went to law school. And then with the water rights, you know, I love helping people protect those rights too. And I do believe that how we utilize the water is key to our future and our communities and how, how we survive into the future. So it's a huge issue. And I think one of the first books I wrote was about water markets in Montana, so that we would have more flexibility to be able to meet the need, the changing needs as we change and as the climate changes. So with that, I have completed everything, and I am open for any more questions. Surely somebody has something.
We do have something. I think this enters into like personal opinion, but I'd love to hear what you have to say. Is there an argument that because property is now so expensive and there's such a wage, I'm assuming, disparity, that property rights foster some type of social inequity?
I have heard that, but I don't think it's a social inequity because, my ancestors immigrated here. They started with nothing. And I think that if you have property rights and you have the right for people to be able to work, to be able to attain property, that, we all have equal opportunity. I don't think that dividing resources because some people have and some people don't, I don't think that that actually protects our freedoms. So I would want to make sure that those who have less now have equal opportunity to be able to attain it. And I do think that's a problem with, an area like Bozeman. I mean, we have such high values here, and it's hard to live here. We're kind of like getting to be like Jackson Hole. But I don't know if that's really an equity interest as much as it is that you have to be able to pay, people who work here and live here have to be able to make enough money to live here. And I'm not sure how we solve that problem as a society. I don't think it's by giving them property or taking away property values, but we do have to find a way that all who live in an area can, make enough money to live there. So.
That was a very hard one and very eloquent on your behalf. Thank you so much.
That one was almost a stumper one.
Yeah. Does anyone else have a question for Hertha? Give them a few minutes because typing, but. I don't see any others. I just have one question for you, though.
Sure.
I'll get back to that. Someone was asking about the slides and if those are available publicly. I believe the answer to that is no. But Hertha, as far as the state bar goes and the law-related education committee, we do appreciate your help, and we would be happy to try and answer this individual's question as far as what may be available in the future, as far as your slides and presentation. I'm not really sure at this point. My question, though, is that do you see, we talked about this a little bit with the climate change, but are you seeing some significant differences in the things that you're litigating today than you have in the past based on changes in property value and climate change and just the influx of people coming into the state that may not have historic land ownership here?
Yeah, so as far as climate change in Montana, which is where I practice, we did have a few dry years, but we've had dry years in the past. This last year has been an extremely wet year for most of the state. So, that you don't see it much there. The biggest change is in land values. I mean, you cannot buy a ranch in Montana based on ag value. And by that, I mean, if you're simply in agriculture and you're going to try to pay for it by working in agriculture, ranching, or farming, most of the land you cannot purchase based on that value. All of the land in Montana has another a value or overlay, which is recreational value. And so there's no doubt that if you can afford the land, it's a good investment because it's been steadily going up. But because it's also so high valued, a lot of regular agriculture people cannot afford to purchase any more land because, again, they cannot pay for it based on what they make in agriculture. So that's another ongoing issue that I see because, do we want to just be a playground for people who own land for recreation? I happen to believe, since I've worked for agriculture my whole career, that agriculture is important, and it's important that we're able to grow enough food for our own, safety. It's a safety issue, and also a life quality issue, that we can, raise quality food in our, close to home as possible. So I see that more than anything, that it's the value of everything, keeps on growing up because we're so popular. So.
I think that makes a ton of sense. I don't see any other questions. Did you want to make some final comments? And then I will remind everybody of what's coming up in the next several weeks.
Sure. Well, I want to thank you all for your kind attention. It's interesting to talk on Zoom and not see you all. I'd love to meet you sometime, and thank you for your interest in the law. It is the foundation of how we all interact with each other, and to me, property rights, as you can tell, is my passion, and I think it underlies so many other things that help our society and our communities stay together and grow together. A good property rights system is a foundational for good government. And again, I thank you for your being here, and I hope to meet you sometime in person. Thank you.
Thank you so much, Hertha, and thank you all for joining us this evening. If you haven't already registered, we do have 3 weeks left. Next week, join us for a primer on criminal law. And the last 2 sessions, legislative changes that impact Montanans, will be on November 29th, and a discussion on family law on December 6th. So once again, Hertha, thank you. You're getting comments that indicate it was an awesome presentation and everybody really appreciated it. And I do appreciate so much that you took the time out of your evening. And for all of you that participated, thank you again. Everybody have a great night.